Okay, everyone, it's really excellent to see such a great turnout, and even more excellent to actually see Hugh Tomlinson QC. Hugh is no stranger to the Faculty of Law. In fact, he spoke at our 2003 EU Internet Regulation Conference, and I believe announced the result of a very important case, Vidal-Hall and Google, in the room, because data protection law and information law is being made right there and then. I can think of no better person to explore how information law is evolving, how privacy, common law privacy, defamation and data protection are evolving together than Hugh. In the interest of fair, transparent processing, by the way, I should say we are recording this, but we're not putting the question and answers after Hugh's talk on the web, but that's just a bit of housekeeping. But aside from that, the floor is Hugh's. Thank you.
Thank you very much. Now I know that the talk is being recorded, but not the question and answer. I'll obviously leave the entirely indiscreet comments to the question and answer. So everything I say in the course of the talk will be measured, sensible, and discreet. So I was asked to talk about the information torts from the perspective of the practitioner. As you will undoubtedly realise, the practitioner comes at these things from a very different perspective from the perspective of, I imagine, most people in this room. We regard these as weapons in the fight on behalf of our clients. And from the perspective that I work, we're usually using the information torts to try and control the flow of information and try and stop information that our clients want to be stopped from flowing down channels they don't want it to flow down. This is, as you will all know, a very fast-moving area. When I started practice in the 1980s, there was 1.5 information torts, there was defamation, and there was the pseudo-tort of breach of confidence. Still, as you may know, still a tort that everybody believes to be a tort, apart from the English judges. A very curious state of affairs, and I unfortunately lost the opportunity to persuade the Supreme Court to take an opposite view, because Google having the case of Vidal-Hall and Google having settled before the Supreme Court had the chance to consider it. Anyway, there are now, I suppose, 4 information torts. There's defamation, the pseudo-tort of breach of confidence, breach of statutory duty under the Data Protection Act, and misuse of private information. Misuse of private information is a strange creature which has existed only for 15 years. Its birth is lost in the mists of obscurity. It actually, I once went to a seminar where several of the judges who were involved in the Campbell case were present and discussed how the tort had come into existence. And all of them accepted that nobody had argued for its existence at all, and nobody could quite remember how the House of Lords had nevertheless ended up recognising it. For 12 years it had a sort of a bizarre status. Nobody really knew what kind of creature it was. But in Vidal-Hall, I suppose one of my few contributions to English law, I persuaded the Court of Appeal it was really a tort. That mattered only for obscure procedural reasons, but it's now a tort, and it seems to me that if the Human Rights Act were to be repealed, it would mysteriously survive, having mysteriously come into existence as a result of the Human Rights Act, but it now seems to have got an independent existence of its own. These information torts for the last 15 years, or whatever period you'd like to take, but quite recently, have nevertheless operated in separate silos. attempt to be amusing in my title refers to some of those silos. Misuse of private information, although strangely enough the first claim was brought by a woman and wasn't about sex. Most of the claims since then have been brought by men and have been about sex. They've been about men trying to stop stories about their sexual activity coming into the public domain. You will doubtless remember some of the famous cases, some of my famous defeats, rather sadly. The CTB case involving Ryan Giggs, which I still believe I only lost because the woman in question was so photogenic that the papers just couldn't resist running endless photographs of her. She turned up in court wearing the most remarkable dress I've ever seen in an English courtroom, and she spent a lot of time posing outside the front of the. She was absolutely insistent. We wanted to anonymise her, but she was absolutely insistent that her name was made public. I think her career took off as a result. But I mean, that was a case about a typical case about a sexual relationship, and the cases have over the years typically involved injunctions and typically involved sexual relationships. And I say the rather bizarre feature of them is that it's dragged the judges into areas of social and sexual morality. So there's the famous comment of Sir David Eadie in Mosley that someone having a couple of people having a joint on their own in a private place wasn't something that there was a public interest in disclosing, even though it's a criminal offence. And then the comments of Mrs. Justice Lang more recently in a case you may not immediately be familiar with called AMC against Group Newspapers, where it was suggested there that my client, who had an affair with a notorious publicity seeker, anonymised, so I can't tell you who it was, a notorious publicity seeker, it was said that this was something that the news, the Sun argued that the case ought to be in the public domain because this was potentially socially harmful conduct, having an affair, and the press ought to be able to criticise socially harmful conduct. And the judge said, I think slightly bemused, Mrs. Justice Lang said she doubted whether the courts were equipped to act as an arbiter of whether conduct was socially harmful if it fell short of illegality, and that thought the whole argument was, as of course it was, entirely got up to sell newspapers. And then perhaps even more notoriously, the more recent case of PJS and News Group, which didn't involve a kiss and tell story by a woman for a change. It was a kiss and tell story by a man about another man, but never mind. But those there've been quite a lot of injunction cases, much less detailed analysis of the law, because a lot of it's gone off on arguability. The way that the procedure works, you very rarely get sustained legal argument or analysis if you're dealing with an interim injunction. But the misuse of private information has until recently just gone down that route to the suppression of information, and the suppression of information largely about sexual activity. Defamation, of course, is a more well understood, well established, and it's so well taught, it's so well understood and so well established that people often don't realise how utterly bizarre it is. It's a tort which operates in a complete fantasy world. Whenever anybody comes to me to advice about defamation, the first thing I say to them is, you've got to understand that defamation is not about the real world. Defamation is about this imaginary entity called the natural and ordinary meaning, something which everybody accepts doesn't exist. It doesn't actually have any real world significance at all, but that's what matters. Truth doesn't matter, actually. It's natural and ordinary meaning truth that matters. But it kind of has it kind of still has a relationship to truth. It kind of still is a tort about truth, and in a kind of well understood way, if you say false things about people, the law of defamation in general doesn't like it very much. And you can often work out a way of turning non-defamatory false statements into defamatory false statements. One of my, I think, greatest contributions to the English law involved a case where my client was a very wealthy man who owned a football club. I can't tell you anything more about it. And the newspapers were running stories saying he was about to sell this football club, and he was very upset because he wasn't about to sell the football club. And so my solicitor rang me up and said, he wants to sue. And I said, well, it's not defamatory to say that someone wants to sell a football club. On the other hand, if he were to make a public statement to say, I don't want to sell my football club, then if they said he wanted to sell, they'd be accusing him of being a liar, which is defamatory. And the Times did that very thing, and we successfully sued them for libel. So we transformed a patently non-defamatory statement into a defamatory statement. But the serious point is that the tort of defamation is essentially, at its essence, is about whether things are true, albeit whether what's true is the imputation which the law draws out of the words. The data protection is a kind of late comer onto the scene, as everyone knows. Data protection was invented in Sweden in the 1970s, the time when they had 40 computers in the country, and the system is now adapted to a system where there's something like certainly well over 1 billion relevant computers in the EU, and still rather sweetly they have the registration system which is supposed to work when there were 40, which when there were 40 did work, but now there's 1 billion doesn't work because most data protection that's done is done unlawfully with unregistered data processing equipment, but never mind. Data protection is rules are breached on a daily basis by everybody on hundreds of thousands of occasions. But it's never, until recently, not been deployed much in legal practice. I think for two reasons. One is a very, in a sense, intellectually uninteresting reason, but probably the real reason is that the judges are an age where they don't really understand computers, and they certainly don't understand data protection, and they think it's all a scurvy trick. And so if you say to a judge, well, this is a breach of the Data Protection Act, there. Yes, let's get on with it and deal with it under some category I understand. And that was long the case, perhaps changing now. But as David alluded to earlier, the case of Vidal-Hall was an important turning point for practice because it meant you could get general damages for breaches of the Data Protection Act. So nobody would sue for data protection breaches because there were no damages available. But now Vidal-Hall has made the Morrison's case possible. You may be familiar with the Morrison's case where 5,000 people have sued over a data breach, and then there's a case coming up where I'm suing on behalf of 5.5 million people over a data breach involving Google. Whether it will work or not is an interesting question, which will be determined by the courts later this year. But so all of a sudden you can get general damages. So, but data protection has been seen as being a very specific tort, dealing really with the operation of data storage systems. I mean, that's what people think of it. Although, as applying to, although of course, as I'm sure everybody knows, the definition of processing under data protection law is so broad that it really, there's nothing in the universe you can do with information which isn't processing. Even just sitting there looking at it is processing. Deleting it is processing, storing it is processing, publishing it, and so on. So in fact, the ambit of data protection is much wider than anybody has really understood to start with. Now, the next, what I want to now move on to is how the apparent boundaries between privacy, it's about keeping true information in, defamation about false information, and data processing about computers, if you like, how those boundaries have become blurred in recent times. That blurring is, I think, the motor for it is obvious. It's the operation of Article 8, the Article 8 case law from Strasbourg. Two areas of particular interest, certainly for practitioners. The first is the notion of false privacy, so which you get a touch of in the Data Protection Act. Something will be your personal data, even though it's completely made up. It doesn't stop it being your personal data that actually, it claims, it names you, gives completely the wrong age and then the wrong medical history. Still your personal data, it just happens to be false. So the notion of false personal data, which you find in French law going back 30 years. I always like to mention this because it sounds entertaining. The case of Bardot and Ici Paris, where the well-known actress recovered damages because there was an article claiming she'd attempted to commit suicide, not defamatory, but private, and the fact that it was made up, that there was no such suicide attempt, didn't bother the French courts at all. They said it was private information, it was just false. And the English courts have taken the same line, and so you can now sue in circumstances which are not clear because they've not been explored in the cases for the publication of false private information. It's a very useful practical tool because, to take a random example, when I was doing a case for the Beckhams and their wicked former nanny sold her story to the News of the World. The story was as to 60% utterly made up and as to 40% true. But what we didn't want to do was to tell the News of the World which bits were true and which bits were false, because that rather helps them run their story. So we said, this is all private, doesn't matter whether it's true or false. So false privacy is an important blurring of the boundaries of private information into defamation. The second area, again, it may be familiar to you, is yet another slightly strange development of the Strasbourg case law, because when the convention was drafted, it was decided not to include reputation, the right to reputation, as a right under the convention. The right to reputation exists in for example, the Covenant, the International Covenant, Civil and Political Rights, and in many other places, but not in the European Convention. However, going back to a case in 2005 called Chauvy against France, the court has come to recognise reputation as a facet of Article 8. You might think, if you weren't in the right subtle French frame of mind, you might think that reputation is public and Article 8 is about private, but no, that doesn't worry them at all. Because your reputation is an element of your personality, which is an element of your Article 8 rights. I have a lot of people complain to me about Article 8, and which is a kind of imperialist right. It's not only has it sort of marched into Poland, it's conquered most of Eurasia as well. It's basically taken over everything, and there are no limits to it. It's all very difficult. But one of the areas where it's undoubtedly now the case law is absolutely clear is that there is an Article 8 right to reputation. So what looked like a defamation claim can be an Article 8 claim, and that's important analytically, because when you're looking at whether an interference with Article 10 is justified, is it justified to fine the press or injunct them or restrict them in some way? If you're looking only at Article 10.2, in other words, you're looking at the question as to whether it's necessary in a democratic society, reputation appears there, but it's one of the justifications for restricting Article 10, and it's a kind of weak little creature lurking at the bottom of 10.2. But if it's an actual alternative additional human right, it starts on as a matter of parity. One of the things that upsets me a lot just in passing, is that there are many people, largely under the influence of American multinationals, who seem to think that freedom of expression is a primary right and the others are all secondary. No. They're all of equal value. And privacy and freedom of expression are of equal value, presumptively, and that none has presumptive priority. How you deal with the balance between them and the facts of a particular case is difficult. As you know, that balancing exercise is actually written into the definition of the tort of misuse of private information. But increasingly, it's something which is coming to be written into the analysis of the tort of defamation, balancing between the Article 8 right to reputation, the Article 10 right to freedom of expression. So you notice that we've got to a position where actually there's no real difference between privacy and defamation. There's no real difference between true information and false information. The analytical framework is the same. How they're dealt with, of course, is all. It requires what we call in the trade an intense focus on the facts. That means we try and work out who the bad guys are and find against them. No, I think we better strike that from the tape. But it's we have to look at the balancing on a case by case basis. And there's no doubt that the English courts have recognised the right to reputation as an aspect of the Article 8. We find that in the Supreme Court decision in Guardian News and Media, where they say in terms that it is an aspect of Article 8, and so there's no doubt about it. So that means that if words are published, if information is published which reflects negatively on a person, it can be the subject matter of a claim in either libel or privacy. I'll refer you to, although I won't go into the details because I'm not sure what so let me just look at the time. I won't go into the details, but just to entertain yourselves, if you have nothing better to do, there's a very entertaining little case called D'Olio and Associated Newspapers in 2011, involving a rather charming lady who I have met called Nancy D'Olio, who was at one time the girlfriend of Sven-Göran Eriksson. She's a rather remarkable character. But she brought a libel action over a piece in the Daily Mail which described her as a man-eater. Nancy's got her claws into yet another high-profile millionaire, it said. The judge said that wasn't defamatory, but there's an interesting discussion of the question of that being an interference with her Article 8 rights. So we get into the position where the courts are in the information law context are balancing Article 8 and Article 10 on a what is sometimes called an ad hoc balancing basis. There are no overall rules. It's the balance is struck on the facts of every case. You see the kind of effects of this being worked out most interestingly in the Court of Human Rights, where in a pair of cases in 2012, Axel Springer and von Hanover number 2, not to be confused with von Hanover number 1, obviously, but the same von Hanover. The Court of Human Rights set out a series of 6 criteria for the balancing of Article 8 and Article 10. The first being the contribution to debate of general interest. The second, how well known is the person and what's the story about. The third is what has the person done, their prior conduct. The fourth is how was the information obtained. The fifth, the content, form and consequences of the publication. And then finally the severity of the sanction imposed. Now, those are kind of analytically confused categories, as is obvious. They kind of don't really properly fit either libel or privacy. But the Court of Human Rights has applied them, particularly they don't fit libel, but the Court of Human Rights has almost consistently, as consistently as that wholly inconsistent institution can be, has applied in libel and privacy cases to balance Article 8 and Article 10. So it's now got to the stage where most of the time, if the Court of Human Rights is looking at a defamation case, it will look at it as a case between balancing Article 8 and Article 10. It won't, as it did 20 years ago, treat it as a pure Article 10(2) case. The English courts haven't quite been drawn down to applying those 6 criteria, although from time to time reference to them is made. The final point I want to make about the blurring of the boundaries is a case which if you read it, looks very unexciting and contains almost no reasoning of any kind. That's possibly too rude. But is regarded in the professions as being a case of, I won't say world historic importance, but quite important, called Prince Moulay and Elaf Publishing, a decision of the Court of Appeal last year, where what had happened was someone was running a defamation claim, and they were a bit worried that the defamation claim wasn't a very good one, because the natural and ordinary meaning you could spell out of the words possibly wasn't defamatory. And so they had the whizzo idea of adding in a data protection claim on the basis of processing of inaccurate data, section 14 of the current Act, and who knows what section of the new Act, 173 and a half or something. The defendant publisher said that was an abuse. You couldn't go around dressing up your defamation claims as data protection claims. That was cheating. And the Court of Appeal said, no, that's fine. They're different rights. That's absolutely fine. So you can sue for, in theory, false information, defamation, false private information, or inaccurate personal data. Take your pick. Now, these days, more and more cases involving publication and processing information by publication encompass 2 or 3 of the torts. I haven't said much about the pseudo tort of breach of confidence. No one really knows whether it kind of still survives in the same form. Sometimes as it used to be. Sometimes the judges say it has. Sometimes they say it hasn't. Sometimes it kind of comes up and is entirely separate from misuse of private information. Sometimes the judges say it's all about reasonable expectation of confidentiality, so it's really the same. Who knows? The final thing I want to say want to consider just briefly is whether this is a trend which will continue, whether they will all combine themselves into an Article 8 tort. Because one thing I always say to people about the Data Protection Act, the Data Protection Act is just actually someone set a parliamentary draftsman the task of making a provision that's so obscure that nobody could possibly understand or follow it, and they produced the Data Protection Act. But when you strip away all the verbiage, when it comes down to it, it's just about Article 8, Article 10 balancing, as ever. So the very same act is just filtered through a set of rules, but that's what it comes down to. So are we moving towards the land where there's a as it were a single information tort, a sort of Article 8 based tort, which you can just about push Article 8 into commercial confidentiality if you're feeling particularly sort of brave and imaginative, because corporations have Article 8 rights, and so you can then libel, privacy, data protection, put them all in one basket and just do a bit of balancing. In practice that hasn't happened, and one of the reasons, and it's the procedural rules remain different. Particularly the so-called rule in Barnard and Perryman, which actually effectively prevents people from getting libel injunctions, doesn't apply in relation to other information torts. So if you can formulate a claim as being in data protection or privacy, then you can get an injunction. If it's formulated in defamation, you can't. So there are other procedural differences between the torts which still exist. But I think there's a more fundamental point, which is that the Human Rights Act liberated the common law judges to go back to issues of principle. That they'd been principle had been, I won't say forgotten, but the question of how you brought in legal values into the operation of the common law had been kind of slightly lost, and the Human Rights Act has brought the judges back to doing that, but they have become increasingly irritated by the Strasbourg case law. The Strasbourg case law is irritating. It's very often very poorly reasoned, quite often doesn't make sense, and it's the only court in the world where the court registrar retires with the judges to deliberate on the decision. And then, of course, the court registrar writes the judgment. English judges, you see some wonderful examples in the case law where they just say, there are 3 Strasbourg cases and they just don't make sense. They're irreconcilable and they don't make sense. What are we to make of them? And I think what's happened over the past 5 to 10 years is the English judges have become increasingly keen on talking about the values of the common law. And so now it's very often the case, running a point in the Supreme Court, it's actually better to run it as a common law values point than a human rights point, because common law values they're interested in, human rights they're annoyed by because of the having to deal with the Strasbourg cases. And so I think the idea that Article 8 has part of its imperialist mission has been to swallow up these fine old English torts, or some of them are not very old and not very fine, but to swallow up these English torts and turn them into one big tort is something that judges do not like. Judges like to keep, and it seems to me that actually, if you like, the trend of blurring the boundaries has probably got about as far as it will get. I think the English judges certainly are more happier with some kind of boundaries, some kind of procedural differences, some kind of procedural rules. So where are the information torts are going in the direction that Article 8 pushes them, but I think you'll find that Article 8 will increasingly become a creature of the common law. Before very long, the whole of the convention will be really a creature of the common law. We'll have forgotten about it, if you see what I mean. The judiciary have got those values. Those values are important. They're central to the rule of law, but they like to reconceptualize them in a kind of traditional English way, rather than through the lens of Strasbourg and its case law. So I think that's about as far as I'm going to. Have I hit my time exactly? That's very well done, I think. So I'm going to stop there and answer questions.